Hello and welcome back to Village Voices, the official podcast for the Village Lab at the University of Manitoba. In this show, we discuss topics from HIV and harm reduction to Indigenous health and community health. We are here to amplify voices, break stigma, share knowledge, and build healthier communities. I'll be one of your co-hosts today. My name is Grace Hallwell. I use she, they pronouns, and I'm the knowledge, translation, and exchange strategist at the lab. My lovely co-host I have with me today is Melissa Morris, who is the manager at the Village Lab. Melissa, would you just like to share a little bit more about yourself before we get started?
Hi, I'm Mel. A lot of people call me Mel. My pronouns are she, they. I'm a Two-Spirit citizen of the Manitoba Métis Federation, and I'm also a Bachelor of Social Work student at the University of Manitoba.
Awesome. So today we are so excited to have André Capretti from the HIV Legal Network and advocate Marj Schenkels joining us for today's discussion on HIV Non-Disclosure Criminalization, specifically within the context of Canada. Together, we'll hopefully take a closer look at Canadian law and how it's been dealt with in HIV non-disclosure since 1989 and reflect on its effects on human rights, public health, and vulnerable communities. Just to kick things off, we'd love to hear more about both of your journeys, André and Marj. Could you tell us a little bit more about yourselves and what sparked this passion for the work that you're doing and what led you to where you are today? André, you can start there.
Great. Thank you, Grace. Yes, first of all, it's a pleasure to be here. Thank you so much for having me. I am joining you from Jojage, also known as Montreal, where I'm from, where I went to law school at McGill University. And that's what really sparked my interest for human rights law and which led me to work in social justice, public interest law, and ultimately to the HIV Legal Network, which is an organization that works across Canada on health and human rights issues, particularly those affecting people living with HIV and the communities that are disproportionately impacted by HIV. It's an organization whose advocacy work I've always admired a great deal. And I wanted to get involved in defending the rights of marginalized people and marginalized communities and get involved in lots of complex but really interesting work that has a positive impact.
Yeah, and we also admire the work that the HIV Legal Network does too at the Village Lab. We use it in most of our infographics. You guys do a great job with consciousness raising and knowing your rights within the HIV community. So thank you for that.
That's
Marj?
great to hear.
Yeah. Marj, how about yourself?
I was diagnosed with HIV about 16 something years ago, and being told that I was one of the first women in Manitoba to be charged for not disclosing. That's where that drive began, being the first one and seeing the unjust in it all and realizing that Manitoba itself doesn't have their own set of laws, so we don't have any set precedent. Manitoba is based off on whatever the judge feels which province they want to pull from. So I feel that it just needs to be decriminalized in general, and that's what I would like to continue to speak up for.
Yeah. I know there's a lot of discretion when it comes to judges' powers within HIV non-disclosure criminalization cases. So thank you for sharing that, Marj.
Is there anything you'd like to tell us about yourself, who you are as a person?
As a person, I'm fun and bubbly, and I am a proud mama of 3 children and 3 kitty cats. I was part of Sisters of Fire, which is a support group for women with HIV, and that has been a lifesaver for me. And through Sisters of Fire, they hooked me up with All Together for Ideas, and it's a group of people that we do research on HIV and the pandemics and other epidemics, and it is so much fun when we get to do outreaches. I love giving back to our community, so yeah, any chance I have to give back to the community, I'm excited about.
Thanks, Marj. Yeah, so I know Marj from Sisters of Fire. That's where we met. I'm also a member. So, yeah, I love Sisters of Fire. So let's begin. Welcome to today's episode on exploring HIV criminalization in Canada. Since 1989, over 200 individuals have faced criminal prosecution for HIV non-disclosure, raising serious questions about justice and human rights. Canada is often framed as a leader or hotspot for HIV criminalization, a reputation that brings no honor. HIV criminalization means unfairly using criminal laws against people with HIV. This includes cases where someone unintentionally transmits HIV, might have exposed others to HIV, or doesn't tell others about their HIV status. The current legal framework requires people living with HIV to disclose their status to sexual partners when there's a realistic possibility of transmission. Failure to do so can lead to severe consequences. However, many argue, including the guests we will be speaking with today, that these laws are unnecessarily harsh and are ultimately effective. The impact of these laws have been particularly severe on marginalized communities. Data shows that Black and Indigenous people face higher conviction rates and harsher sentences. While recent years have seen some positive changes, including fewer prosecutions for individuals with suppressed viral loads, the challenges have not vanished. Today, we're honored to welcome our panelists who will contribute their unique perspectives to this rich discussion about HIV criminalization in Canada.
Yeah, I think our first question we wanted to start off with was actually one that we were going to direct towards André. We've heard from community that HIV non-disclosure criminalization is a topic that many don't fully understand. And it's such a complex topic too, especially provincially. So for someone that might be hearing about this topic for the first time, could you break down what HIV non-disclosure means and why it's such a complex issue?
Absolutely. I've been working on this issue, the HIV criminalization file, for over 2 years now at the Legal Network. And still to this day, I find it often challenging to explain to people because it is just so inherently complex. And part of that complexity comes because, the science of HIV transmission tells us one thing, and then you have the law, the criminal law in Canada, which is sending a completely different message, which is not aligned with the science. And, that also comes from the history and the reality of misinformation, of stigma, of ignorance around HIV in Canada, but also elsewhere, which still shapes how people understand HIV, how they think of HIV transmission risks, and how they judge people who disclose or don't disclose their HIV status. So I guess what's important to know from the outset is that the law, when we talk about HIV criminalization, we're mainly focusing on HIV non-disclosure in the sexual context. So when a person living with HIV does not disclose their HIV status to a sexual partner before sexual activity, but we know that there are also examples of cases and, risk of criminalization in some other scenarios as well. You can think of vertical transmission. So a mother or a birthing parent to a child, also scenarios around breastfeeding or chest feeding. And more, there's, thinking being done around the possibility of HIV criminalization around shared injection drug equipment. But what's important to know is that the law that we have, the decisions that have, built and developed the law in Canada come from that scenario of a sexual encounter.
Mm-hmm.
So as you already kind of explained in the intro, the law imposes a positive obligation on people living with HIV to disclose their status where there is a realistic possibility of HIV transmission. And what that means in practice is not clear because it can depending on a province, what courts or prosecutors interpret as a realistic possibility of transmission. It can also depend on a sex act, if we're talking about oral sex, anal sex, vaginal sex, or other sexual activities. So there's a lot of divergence, there's a lot of inconsistency, and that really contributes to the impression, the right impression that people have, that it's not clear when they might have or not have a legal obligation to disclose their HIV status. And when we know that the the consequences of not disclosing your status, the criminal consequences, the possibility of facing really harsh prison sentences or registration as a sex offender. When you have such harsh consequences as a risk for a person, it's even more important for the law to be clear, to be consistent, and I guess we'll get to this later as well, but for the law to be aligned with the actual scientific evidence, the scientific consensus around HIV transmission. So that's a little kind of maybe intro explainer to why it's such a complex issue.
Yeah, thank you so much for sharing. And I think it goes into what Marj was saying earlier and how like the discretion of judges have in court. And do you think it ties back mostly to that idea of what is considered a risk of transmission?
Yeah, so I'll give maybe a bit more context to how the law developed in Canada. Back in the 1980s, we saw the first cases of criminalization of HIV non-disclosure, but Canada doesn't have a criminal offense in the criminal code of HIV non-disclosure. It was something that, judges had to use existing criminal offenses and take the phenomenon of HIV non-disclosure and kind of put it on those existing offenses. So it developed slowly and incrementally over time through court decisions, which means it also involved, evolving in a piecemeal fashion at times. And that could depend on, province by province, judge by judge, what they perceived or determined might constitute a realistic possibility of transmission. In 1998, and then again in 2012, the Supreme Court of Canada, the highest court of the land, came to a decision in two cases involving HIV non-disclosure to try and clarify what kind of the legal standards were, what the legal requirements would be for disclosure. Unfortunately, it doesn't give us a ton of clarity. It gives us some idea of scenarios where people won't have a risk or won't pose a risk of transmission and therefore won't have a legal obligation to disclose. But they didn't necessarily answer the question of when is there a realistic possibility of transmission. So in that case, the Supreme Court of Canada said there is no realistic possibility of transmission and therefore no legal obligation to disclose when a condom is used and the person living with HIV has a low viral load, which they set at roughly 1,500 copies per milliliter. So the Supreme Court of Canada said in that scenario, we're confident that there's no realistic possibility of transmission, and therefore that person does not have an obligation to disclose. But they also left open the door that, scientific evidence, scientific research would develop, would evolve over time, and there would be other scenarios where we could say that there's no realistic possibility of transmission. But that means that since 2012, different courts have started interpreting that standard differently. We have some provinces which really recognize U equals U, the idea that an undetectable viral load means a person cannot transmit HIV to sexual partners. But unfortunately, that is not explicitly or formally recognized everywhere in Canada at this point in time.
Thanks, Andre. Marj, you spoke to us about being criminalized for HIV. Could you share about your experiences navigating the legal system?
Navigating the legal. I didn't have the first clue when I first got charged. I was way too much shock. And it was honestly my social worker at the time that hooked me up with my lawyer who had no clue about HIV. So it was a learning experience for both of us. And it was, I can't remember if it was the first appeal or the second appeal. He had actually reached out to the legal network for HIV, but judge's rule, no, he can do it himself, even though he doesn't know anything about HIV. So it was it was confusing for both of us, both me and my lawyer. And I can say he did his absolute best. And I didn't know that I was being charged for non-disclosure until sentencing. I thought I was being charged for transmission because of the wording Andre just used there, the whole unreasonable doubt of transmission. So I'm sitting there in the courtroom thinking, am I being charged for transmitting it to him or not for telling him? I don't know what's going on anymore. That's our legal system for our lawyers and peers.
Yeah. Thank you for sharing that, Marj. I think it also reflects some of the similar challenges that other people facing HIV criminalization experience all over Canada. Again, for Andre, Canada uses regular criminal laws like sexual assault charges to deal with HIV criminalization cases rather than having HIV specific laws. UN-AIDS suggests two options, either that countries get rid of specific HIV laws or only charge people who deliberately spread HIV. How do you think Canada could change its current approach to better match those recommendations? And why do you think the Canadian justice system might be reluctant to this change?
That's an excellent question. First of all, the HIV Legal Network is part of the Canadian Coalition to Reform HIV Criminalization, which is a group of different HIV ASOs, so AIDS service organizations, activists, advocates, people who have been criminalized, academics who work on this issue. And the coalition has developed certain, points of advocacy where we want to see the law change in Canada and how we want the law to change. So we do want it to align to what organizations like UN-AIDS recommends. First of all, the point about HIV-specific laws and how it currently works in Canada. So our hope and what we've been advocating for many years is that the Canadian Criminal Code itself would be reformed. And by reforming the criminal code, the hope is that you can add in language, the criminal code, that would prevent criminalization for HIV non-disclosure in certain cases. And the idea is that you would address the problem at the root rather than waiting for judges and the courts to, slowly but surely get on board with the law, with the science, the human rights arguments. So we advocate for criminal code reform as the first step. And we think it's incredibly important to take it out of sexual assault law, because currently it's primarily, but not exclusively, an issue which is prosecuted under sexual assault and aggravated sexual assault, which is one of the harshest criminal offenses in the Canadian Criminal Code. That's a characterization, a qualification, which leads to a lot of stigma, conflating HIV, people living with HIV with sexual offenders. It's incredibly harmful. It leads to registration on the sex offender registry and other, major harms. And then there's this whole discussion around HIV-specific laws. And we know that there's some jurisdictions, some states in the US or some countries in the world where they have HIV-specific laws. And our position, there's, a concern around stigma of having HIV-specific laws, of making it clear, making it black and white in the criminal code that we have a certain criminal offense that is for people living with HIV. And that's something that, can lead to even further stigma and create this scenario of HIV exceptionalism, where we're treating people living with HIV differently and harshly and worse compared to any other person. So that is not something that we necessarily advocate for. We advocate for using existing criminal code offenses like regular assault, not sexual assault, but assault, in other contexts, also called simple assault. And then Marj made a great point about how in Canada, the law does not only criminalize cases where there actually is transmission. It also criminalizes cases where there's an exposure to the risk of transmission. And that's something that we advocate against. We think it should change. That criminalization should really be limited to the truly worst case scenarios, which are incredibly rare in any event, of someone who intended to transmit HIV and actually did transmit HIV. That's something that would really align with what UN-AIDS and many other health and human rights organizations call for. And then we also think it's important to kind of have explicit language that excludes the possibility of criminalization for people who have taken reasonable precautions to prevent transmission. You know, under the current Supreme Court standard, I said it was condom use and low viral load. Mm-hmm. We know that a properly used condom, where there's no breakage, no tampering, no holes, no removal, is 100% effective to prevent transmission of HIV. And so a person who uses a condom, but who might not have a low viral load, is still making the effort to taking precautions to prevent transmission. And that is not the kind of person we think should face criminal consequences. It doesn't make sense to criminalize people for taking, reasonable precautions. And then you asked a question about why it is that the Canadian justice system is so reluctant to change. I think that's a really great question that we could spend a whole hour and a half answering. I think it boils down to a lot of different things, but the justice system, the legal system is, very conservative, small c conservative. It's very slow to change. It's focused on incremental responses, piece by piece, rather than, big changes all at once, not wanting to rock the boat. And I think it has to be said that HIV stigma, misunderstanding around HIV, exceptionalism around HIV plays such a big role in influencing how judges and prosecutors and police and victims, in quotation marks, people who bring these cases to court, how they view HIV, how they sometimes overestimate the risk of transmission in any given case or scenario, and how they sometimes or often attribute some kind of moral fault to people living with HIV. That's what HIV criminalization really is at the end of the day. It's treating people living with HIV like criminals, and it's treating them like criminals for wanting to engage in the most normal, human activity possible, wanting to love someone, wanting to engage in sexual activity with someone. So I think that's part of the answer, but not the full answer for sure.
Thanks, Andre. Marj, listening to what Andre had to say about the stigma, the exceptionalism in treating people living with HIV differently, how do you think these approaches affect people living with HIV?
Knowing that HIV is both treatable and preventable, why does the world need to know our statuses? And then also agreeing there are way worse crimes under the aggravated sexual assault umbrella that not disclosing should not be there. And then the whole condom thing. So I have a low viral load. There's a condom properly being used, so I don't need to disclose. Or let's say the partner doesn't even want to use the condom, so you're still low viral, you're still undetectable, you're untransmittable, you don't disclose. But let's say they have chlamydia or syphilis. Now I'm at risk. So it really does criminalize HIV. It makes HIV more stigmatizing. Like, we're all told there's a cure for syphilis. You just need to go get a needle in your ass twice and it's gone. There's a pill you can take for chlamydia. It's gone. I take meds every single day. I'm untransmittable. I'm undetectable. It's basically gone. Why do I need to disclose that? The only thing but it's not for every person with HIV because everybody has a different mental state when it comes to HIV. So for me, it's like before getting charged, I was terrified. I didn't want to disclose. That's my personal life. Now, after being charged and my name being in the news and in the media, now thanks to that, as horrible as that was for my confidentiality being ripped away from me, it made me a better advocate. Now I allow the world to know that I am positive, but guess what? I'm also undetectable. I have 2 children that I birthed while positive, and they're negative. I've been with the same partner for 13 years. He's still negative. Why are we still criminalizing HIV when it is treatable?
Yeah, you're so right, Marj. I always think too, the standards are so different for HIV compared to other STIs or STBBIs, right? And to my understanding, I also have my qualms about the exemptions to HIV disclosure, specifically the condom use one. I agree with you. I also don't think that everybody has the not everybody has the choice on when and how a condom's used. So I think that that could also impact things as well. Like you were saying, like it could make you more vulnerable as well. And also could potentially make specifically women more vulnerable to HIV non-disclosure criminalization. Thank you so much for sharing, Marj. André, you were talking about how the recent research is not aligning with the criminal justice system and what we're seeing in courts. Could you talk a little bit more about it and say a little bit more on how the courts could catch up to the most updated research on HIV non-disclosure?
Yeah, absolutely. So the first point, it has to do with viral suppression. So I imagine that most listeners will be somewhat familiar with what that means when we talk about viral load, undetectable, suppressed, low viral load. But maybe a quick reminder for folks, or brief explainer for people who aren't aware. A viral load, for when we're talking about HIV, is the amount of virus that a person has in their body, and it's measured by copies per milliliter, copies of the virus per milliliter of blood. And we know there's a international scientific consensus which says that when a person has a suppressed viral load, and that means under 200 copies per milliliter, that means that that person cannot transmit the virus to their sexual partners, even if no condom is used. That is something that has been confirmed time and time again by many large-scale international research studies. Scientists know this 100% with certainty. And we can also say the same thing about people who are undetectable. An undetectable viral load is even lower than a suppressed viral load. Often we're looking at a kind of benchmark around 50 copies per milliliter, but the message is still the same. Undetectable equals untransmittable. That person cannot transmit the virus to any sexual partner, even if no condom is used. And there is also, more and more scientific research being done. Recently, or a year or two ago, there was the World Health Organization, one of the leading international medical bodies, which released a policy brief, a document on viral suppression, where they were even going further and saying that, suppressed, we could even raise that standard from 200 to 1,000 copies per milliliter, and say that in that case, that person poses zero risk of transmission, or as close to zero as you can possibly get. So that is the first thing, viral suppression. How do the courts treat that? How do they understand it? If we look back to the Supreme Court decision, they were saying condom use and low viral load. If you were undetectable, they would still say you also need to wear a condom, even though that, that's kind of extra, that's on top of what already needs to be done. It's not necessary. Mm-hmm. The scientific evidence tells us very clearly that undetectable would be and should be sufficient on its own for us to be certain there is no possibility of transmission. How it works in Canada is that there are certain provinces and certain territories which have started to recognize this scientific research, the development in scientific knowledge. And they've done that through what we call prosecutorial directives or prosecutorial policies. And what that means is that the prosecutors in those provinces have specific rules that they follow when it comes to HIV non-disclosure cases. And if they follow these policies as they're supposed to do, then in these provinces, they will not prosecute someone who has had a suppressed viral load for, between 4 to 6 months, even if that person did not disclose and did not wear a condom. So let me kind of back up and reiterate. We're talking about Ontario, British Columbia, Alberta, Quebec, and the 3 Northern Territories, the Yukon, Northwest Territories, and Nunavut. In those places, they have policies. The policies say a person who has a suppressed viral load for at least 4 to 6 months should not be prosecuted for not disclosing their HIV status to a sexual partner, even if no condom was used. So that is, good news. That's a positive development. But we don't have policies like that in Manitoba. We don't have policies like that in Saskatchewan, in New Brunswick, in PEI, in Newfoundland. It's not the same everywhere across Canada. So that's the first thing, viral suppression. For condom use, the scientific knowledge tells us one thing: a properly used condom, no breakage, no tampering, no removal, 100% effective. And unfortunately, we still know of cases, including as recently as 2020, 2021. One example in Ontario, for instance, of an individual who wore a condom during 3 sexual encounters. The individual did not have a low viral load, so it was above 1,500, but they wore a condom. There was no allegation that the condom was removed, that it was tampered with, or that it broke. There was no allegation that the individual wanted to transmit HIV, and there was no transmission of HIV to any of the 3 people. And that individual was still prosecuted, was still found guilty, and even though they appealed to the Ontario Court of Appeal, the Ontario Court of Appeal confirmed that decision and said, no, they should still be found guilty, and they had to serve prison time for that. So that kind of example really goes to show how far the law still is from the science. That is not a kind of person who poses any kind of risk of transmission. And you can see from their behavior that they are taking reasonable precautions to prevent transmission, and they aren't transmitting the virus. So, that kind of defies understanding. In terms of the prosecutorial policies that I spoke about, there are a few jurisdictions. We're talking about British Columbia and the 3 territories, Yukon, Nunavut, and Northwest Territories. In those places, the use of a condom is also something that can mean that a person won't be prosecuted for non-disclosure. So that's a good thing, but that's not the case in the rest of the provinces. And then you can also talk about oral sex. People often don't realize that oral sex poses way, way, way less risk of transmission than anal or vaginal sex. And, the scientific consensus around the risk of transmission in cases of oral sex is that it is almost zero, or it's a negligible risk of transmission. So we're talking about a very, 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 very low risk of transmission. And that kind of begs the question are those the cases, the scenarios, the levels of risk that we think deserve criminal consequences? My answer is no, I don't think so. I think that there's all kinds of, risky behavior in life that is not criminalized, that, if we were criminalizing oral sex because we think it's risky, then those other things should be criminalized instead. But that's also something that should be reflected in the law, that people who, engage in oral sex do not pose a realistic possibility of transmission. And then we could also talk about stuff like PrEP and what that means for risk of transmission when, a partner is on PrEP. And also to go back to this idea of what it means to be living with HIV nowadays. And, you take your meds every day, and you can live the same happy, healthy life that anyone else who doesn't have HIV would lead. I think we're still very much influenced and impacted by this outdated view of HIV as a death sentence. So those are some of the ways that, the law still needs to catch up to the science.
Thanks so much, Andre. Marj, I want to ask you a question about, again, what Andre was talking about, but also the effect that the stigma and discrimination around HIV criminalization have on people that are looking to get tested, that are seeking treatment for HIV, and receiving care and support for HIV.
Okay, sorry. What's the stigma and what do people feel?
How does it affect people? So, do you think that it affects people wanting to get tested, the fear of HIV criminalization? Do you think that it affects people looking to get on treatment or receiving their care and support?
Most definitely. You find out that if you get a positive result, there's a chance that you're going to get criminalized. Who wants to find out their status if that's a risk? Or you already know your status. Now you're afraid to have sex because what if you have sex? Now you're going to get criminalized. It's a real huge fear out there.
Yeah, it doesn't incentivize people for going out and getting tested too. And I think it really brings, I've heard the line before, it brings the government into the bedrooms of vulnerable people, of people living with HIV. So I completely agree with you, Marj. Andre, should HIV non-disclosure be regarded as a public health issue rather than a matter of a criminal justice issue? And if so, why? Or if not, why not?
Yeah, well, I think that feeds in well into Marj's response, is that criminalization of HIV non-disclosure is bad for public health, first and foremost, because it disincentivizes the testing and the treatment, and also stuff like counseling. You know, we've seen examples of people living with HIV who, when they were criminalized for non-disclosure, they end up in court and then their medical records are subpoenaed, or doctors and nurses or social workers are forced to testify against them. And what that kind of creates is a chilling effect where people might not feel as comfortable being open and transparent, communicating with their nurses, their doctors, their social workers. And that's not good when you're trying to establish, a positive relationship between a patient and a healthcare provider, a positive supporting relationship. So that's bad for public health as well. And what I also like to emphasize is that when you have a criminal law that is overly punitive, that is punishing people living with HIV for cases and scenarios where there was no risk of transmission or the risk was incredibly, incredibly low, the law is sending the message that those people did something wrong or put people at risk. And that's a false message. And what that means is that the law is sending inaccurate kind of public health messaging about HIV transmission risks, which is why to this day, when I speak to people about this, people have this sense of inflated risk, or they overestimate the risk of transmission in any given case. And that is why, or how they justify HIV non-disclosure needing to be criminalized in their view. So that I don't think is good for public health. I think we'd be better off if people were properly educated about the science, about the actual transmission risks, about different measures of precaution that people can take, whether that's condom usage or ARVs or PrEP, stuff like that. And ultimately, that would serve us much better than using a really blunt instrument like the criminal law to address a health issue. We saw examples with COVID as well, or other health, emergencies or issues. The criminal law is not the right tool to address those public health issues. Punishment is not going to get you to better health outcomes. What we need are measures that create a safe environment, that support people, that enables them to seek testing and treatment, to get counseling, to have a positive supporting relationship from a healthcare provider. which enables them to get to a place where they're able to safely disclose their HIV status, free of stigma, free of discrimination, free of fear that they might be criminalized. That would be way more useful and better for public health than a punitive approach to HIV prevention, which, the data, the research shows there's no positive impact. It's actually the opposite. Places that criminalize HIV or, criminalize same-sex relations, for instance, those are places which have higher rates of HIV infection. So it's not beneficial for sure.
So Andre, thanks so much for that. Marj, I'm curious about if you would like to share a little bit about that punitive treatment that you received. Do you want to talk a little bit about the aftermath of being charged and what consequences you had to serve?
After the charge and sentencing, yet doctors, I'd never looked at it as them being forced to speak against us. I actually resented my first doctor because of that. I switched doctors because of that. I don't make eye contact with that doctor anymore because of what happened in the court. But now after the whole hearing, the whole being forced into it, I see it in a different light now. So thank you for that. The after effect, it's an automatic 10 years on the adult registry. It's not a matter of if and or, it's automatic. I have 2 years left on there. And it was an experience that I don't want to relive.
For sure. Thanks for sharing, Marj. And I think kind of tying in what Andre was saying earlier, I think this improper messaging that we're getting from the criminal justice system and the public and public health is, I feel like it's really vilifying people living with HIV as well. And I've seen it in the media too. I've seen it just in newspaper articles, right? And I think that also that can change people living with HIV, their perspective about themselves and how they feel about themselves, right? Like when you have all this crappy messaging coming out, right? It's not going to make you feel too good. Thank you for sharing. Andre, the House of Commons Standing Committee on Justice and Human Rights made a significant recommendations. I think it was in 2019 regarding HIV criminalization. Could you explain a little bit more to our listeners about what their recommendations were and how do you think that would actually look like off paper?
Yeah. So I mentioned previously that my organization is part of this coalition, Canadian Coalition to Reform HIV Criminalization, which has been working on this file, on this issue, trying to reform the criminal code for many years. And if I kind of lay out the timeline for you, back in 2016, when we had Minister of Justice at the federal level, Jody Wilson-Raybould, she was kind of the first person in the federal government to recognize that this was a problem. There was over-criminalization of people living with HIV. This was unjust. The criminal law was casting too wide of a net in terms of who it punished, who it criminalized. And then in subsequent years, there were many other kind of there was more recognition from the government at different points in time, the federal government, that this was a problem, this was an issue, it impacts certain communities disproportionately, worse than others, including Indigenous communities and African, Caribbean, and Black communities in Canada, the 2S LGBTQ plus community as well in Canada, and that this is something that needed to change. And that brought us to 2019, when this was studied formally by this House of Commons Committee on Justice and Human Rights, and they released a report that echoed a lot of the recommendations that we have as a coalition about measures that need to be taken to address HIV criminalization. That includes stuff like removing it from sexual assault law, and that would, help with stuff like the mandatory registration on the sex offender registry, removing that requirement, limiting criminal charges to cases of actual and intentional transmission that we say would allow us to really focus on those incredibly, incredibly rare cases where we might potentially all agree a person, might deserve some kind of criminal consequences, but otherwise, the vast, vast, vast majority of cases do not involve intent to transmit. And actually, more cases in Canada that of criminalization involve exposure to transmission, but not actual transmission. So that's something else that we advocate for, and that the House of Commons Committee agreed about. And also, making sure that, like I said previously, people who take reasonable precautions aren't included in the criminalization as well. Now, in terms of understanding why it is that report came out in 2019, we're now 2025, and we still don't have criminal code reform, it's a great question. Since then, we also had we conducted a national consultation where we went, to community members, to people living with HIV across the country, and asked them for their thoughts, for their views, for their insights, their positions on these issues. We developed a consensus statement. We've used that for advocacy. We went back to the government, tried to push them to adopt law reform. They decided to conduct their own national consultation in 2023. And since then, it was radio silence. And actually, back in November 2024, just a few months ago, we got the really unfortunate news, the confirmation from the Justice Minister's office, so Justice Minister Arif Farani, that after all, they were not going to be moving forward with law reform, despite, the commitments and the promises that had been made for years and years and years, and all kinds of recognition from the federal government that this was a problem, this was unjust, this should change. They ultimately decided that they wouldn't go ahead with the law reform. And that was very disappointing for us as a coalition, for people living with HIV across Canada. It was a huge missed opportunity. And I don't know if this was part of your question, but maybe in terms of explaining why that didn't come about, it's hard to separate this or divorce this from the messy reality of politics. And these are politicians, our lawmakers are people who think about elections and how to get votes and how to appeal to voters or constituents. And the really unfortunate thing is that this isn't necessarily seen as an issue that is a vote winner, something that would be popular. The politics of HIV are not popular. They might see it as a small constituency of 65,000 people living in Canada, and they don't necessarily feel like it's a priority. And I think most of all, they know it's wrong. They know they should act, but they don't have the kind of moral conviction to risk losing votes or risk doing something that people more broadly in society might have trouble understanding or might need, extra time, extra education to be convinced or educated on. So yeah, that's where we're at currently in 2025, is that we've been told law reform is not currently going ahead. That doesn't mean that we've given up. It doesn't mean that it's not a possibility moving forward. It doesn't mean that there aren't other ways to advocate for change to the legal system, and other, ways of improving the situation of people living with HIV. But that's where we currently are.
Kind of really quick, even though it wasn't really on the question sheet, what would you say to just the average listener and how they can help support the work that you're doing, the great, great, great work that you and the HIV Legal Network are doing?
Oh, thank you. I think the first thing is to be ready to start by listening, start by educating yourself, taking the time, recognize that this is not an issue that most people are going to understand or get on board with in the matter of 30 seconds or 1 minute. For a lot of people, you really need to start from the basics of what is a viral load and what is, the reality of the scientific situation at the moment. from there, I hope that, once we make the case to people, once we make it a case about individual human rights, about people living with HIV, about the public health argument, about the communities who are being disproportionately impacted and unjustly targeted and affected by criminalization, how this serves no real benefit in terms of HIV prevention, how it's something that, all kinds of government officials and international organizations agree with us on, that it needs to change. Once people are on board with that, then I think they can better advocate, better spread the word, better spread the message, help in any way possible reduce the stigma, reduce the misinformation around HIV within their own communities, within people they know, and then make it known to your politicians that this is something that you care about, that is a priority for you, that you think should change, needs to change, that you want your government to do. And that can be at the federal level with federal politicians, but there are also opportunities for change at the provincial level. And I say this as well for maybe a Manitoba audience, is that I mentioned there are no prosecutorial policies or prosecutorial guidelines in Manitoba at the moment, which means that Manitoba prosecutors and judges and courts rely on that 2012 Supreme Court decision, the one that said condom use and low viral load. And we know that that's outdated. We know that Manitoba can do better. We know that there are other provinces and territories that are doing better. So that's something where you can even advocate to provincial politicians, members of the Legislative Assembly in Winnipeg, that this is something that the government needs to change. And maybe with the current government in Manitoba, that is something that could realistically change moving forward.
Great. Thanks so much, Andre. We have one final wrap-up question for you, Marj. And we'd like to know what resources and support systems would help people living with HIV navigate these disclosure conversations.
Two really great places that I like to go to for support are the Lodge with Gani Ganichik and Nine Circles. They have amazing people that are really well educated. Obviously, you have the nurses and the doctors at Nine Circles, but what makes the Lodge really awesome is they treat you more like family and you're normal. You're not being judged. You're not being stigmatized against. You're an everyday normal human being. And I think that's what everybody needs to feel.
Thank you so much, Marj. So in today's episode, we delve deeper into the topic of HIV non-disclosure criminalization in the Canadian context. We are so deeply grateful to both of you to have shared this conversation with us. Until next time, you can keep up with any updates at the lab and everything that we're doing, and also send any thoughts or questions to @UMVillageLab on Instagram, Facebook, Blue Sky, and YouTube. Again, thank you so much, Marj and Andre, for taking the time to talk with us today. I can say I definitely learned a lot from both of you during this conversation, and I really hope the listeners at home did as well.
Great. Thanks so much.
Thank you so much, guys.
Thank you so much.